This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to talk about the CrimeFraud Exception to the attorney-client privilege and the work product protection. A waiver of the privilege may result when the insurer is sued for bad faith and/or fraud. For example, California Evidence Code Section 956 provides, quote, "There is no privilege under this article if the services of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit a crime or a fraud." Close quote. Even without a statute, the license to practice law is not and never has been a license to commit a crime. One federal court ruled that a bad faith claim not involving fraud is insufficient to trigger the exception. This is a case called Freedom Trust versus Chubb, a U.S. District Court of California 1999 decision. In the Freedom Trust case, the insured argued that the privilege had been waived because the insurer denied coverage in bad faith. The court recognized that the attorney does not have to be aware of the fraud for the CrimeFraud Exception to apply, and that the fraud exception includes civil fraud. The court noted a split of authority nationally as to whether a bad faith claim triggers the CrimeFraud Exception. The court concluded that an allegation of a bad faith denial of an insurance coverage claim was not sufficient to trigger the exception. It said, quote, "Bad faith denial of insurance coverage means simply that the insurer breached an implied contractual agreement to act faithfully to an agreed common purpose consistent with the reasonably justified expectations of the other party. This need not implicate false or misleading statements by the insurer. For example, an insurer may act in bad faith if it simply denies coverage without any explanation. The gravamen of fraud, however, is falsity. Thus, bad faith denial of an insurance coverage is not inherently similar to fraud." Close quote. This decision was not meant to imply that an insurer cannot engage in activities that implicate both bad faith denial of coverage and fraud. Rather, it means that the simple bad faith case is not per se, is not automatically within the CrimeFraud Exception. In many circumstances, an insurer's bad faith involves fraud or allegations of fraud. Conduct that constitutes a breach of the implied covenant of good faith and fair dealing is often alleged to be fraudulent conduct without an ability to prove that fraud actually occurred. California courts have noted that bad faith conduct involving deceit has often been regarded as fraudulent. If a carrier denied coverage for a claim that it knew was covered, it may have engaged in fraud, and a plaintiff may be able to prove that it did so. Under both federal and Connecticut law, the party seeking to defeat the attorney-client privilege through the CrimeFraud Exception bears the burden of showing there is probable cause to believe that 1. A fraud or crime has been committed, and 2. The communication in question was intended to further the fraud or crime. The crime-fraud exception applies only where there is probable cause to believe that the particular communication with counsel or the attorney work product was intended in some way to facilitate or to conceal criminal activity. The crime-fraud exception to the attorney-client privilege, therefore, is a limited one, and the burden of proof is on the party seeking to pierce the privilege. The exception applies only after a determination by the trial court that there is probable cause to believe that a crime or fraud has been attempted or committed, and that the communication was in furtherance of that crime or fraud. The crime-fraud exception to the attorney-client privilege cannot be successfully invoked merely upon a showing that the client communicated with counsel while the client was engaged in criminal activity. However, when an insurance company client used his attorney's assistance to perpetrate a crime or fraud, he may not assert the work product protection as to documents generated in furtherance of his crime. The attorney who does not knowingly participate in the client's crime or fraud may, on the other hand, assert the work product protection as to his opinion work product. Where the client was the subject of a grand jury investigation to determine if he had received improper payments, the client retained an attorney to assist him in responding to the investigation. The client provided his attorney with a false story to explain how he had received money. Subsequently, in 2005, the government sought to obtain both testimony and documents from the attorney and the attorney's law firm. The law firm responded with a privilege log identifying 1,604 documents it claimed were protected by attorney-client privilege or work product protections. The attorney refused to answer the grand jury's questions on the basis of attorney-client privilege. In June 2006, the grand jury indicted the client and another party, and the court concluded that the attorney-client communications and attorney work product are privileged or protected and ordinarily not discoverable, even to a grand jury. The court explained, however, that neither of these privileges or protection is absolute, and that the crime-fraud exception provides that the attorney-client privilege will not protect communications where the client is seeking legal advice in furtherance of a fraud or a crime. The court stated that while ordinary work product is usually discoverable upon a showing of substantial need and the inability to obtain the same without undue hardship, opinion work product enjoys a nearly absolute immunity and can be discovered only in very rare and extraordinary circumstances. In a case where the government argued that therapists' records are not privileged because they were not created with an expectation of privacy, that the privilege was waived by asking the VA to review the records as part of a benefit application, and that the records were created as part of his plan to defraud the VA and thus fell under the crime-fraud exception. The district court agreed and ruled that the crime-fraud exception defeated any claim of privilege. This was United States v. Bowline, a 2019 decision of the 10th Circuit. The work product protection, often misconstrued as a privilege, is not designed to protect the client. Rather, it is an attorney's independent assertion of his work product protection to keep his or her work inviolate and not available to an opponent. It stands on a very different footing than the attorney-client privilege because the attorney's protection is based on the attorney's interest in protecting his opinions and thought processes from disclosure. This is a protection that benefits all of the attorney's clients because it accords attorney a measure of privacy within which he can candidly compose his thoughts. To his work product, the fraud exception does not apply. In Miller v. National American Life Insurance, a 1976 decision of the California Court of Appeal, the insured sued an insurance carrier for breaching its contract and for fraud in inducing the insured to purchase the policy. The insured argued that the policy expressly obligated the carrier to pay his monthly mortgage payments in the event he became totally disabled. The carrier argued that because these representations were contained only in the insurance policy, they were insufficient as a matter of law to support a fraud cause of action. The court disagreed. Insurers must be careful when asserting the advice of counsel and ascertain that the following is true. 1. The advice given was fair and reasonable. 2. The insurer's employees reasonably relied on the advice in reaching the decision to deny the claim. 3. The attorney giving the advice can testify before a trier of fact in a reasonable, intelligent, and believable fashion to establish that the advice given was sound, and 4. That the advice establishes a genuine dispute between the insurer and the insured or was fairly debatable. In that regard, whenever I represented an insurer in an insurance coverage case where my opinions were to be used to deny a claim, I refused to ever represent the insurer in a litigation brought by the insured for breach of the covenant of good faith and fair dealing, because I knew that I, as the person giving the advice and providing the insurer with a reason to assert a genuine dispute existed between the insurer and the insured, or that the dispute between the insurer and the insured was fairly debatable. As trial counsel, I could never testify. As an independent attorney giving advice to a client, I could testify and support the perfect or at least reasonable defense to a claim of the tort of bad faith. This video was adapted from my book, Zelma on Insurance Claims, Part 106, Second Edition, which is available from Amazon.com as both a Kindle book and a paperback, and is one of the 10-volume work called Zelma on Insurance Claims. If you found this video to be of use to you or of interest, please forward it to your colleagues so that they can also learn what you have learned. Please also subscribe to my YouTube channel and my Rumble channel and to my blog so that you can be advised of all future blog postings and videos. Thank you for your attention.